Hello, let's continue with the Judicial Plan of 1793. We are discussing judicial reforms of Lord Cornwallis, and in that we are going to discuss Judicial Plan of 1793. So let's discuss the reforms. The reforms of 1790 could not bring the desired results, which necessitated further changes. Separation of executive and the judiciary. The powers vested in the collector were administrative and judicial, as he was also in charge of collection of revenue and for deciding cases arising out of revenue matters. All revenue suits were transferred to the court of Diwani Adalat. In this way, the collector was left only with the work of revenue collection and thus divested of all judicial duties. Now, the collector was only responsible for the collection of revenue. Then the next reform was Mal Adalats were abolished. Revenue courts which exclusively tried cases, revenue courts that is Mal Adalats, which exclusively tried cases arising out of revenue matters and presided by the collector as a judge was now abolished. All powers and pending suits of revenue courts or mal adalats were now transferred to Moffisil Diwani Adalat and thus not tried by the collector. Under this plan, executive officers were answerable before judicial court or before civil courts. So, executives subjected to judicial control. The Governor General and his council were now subject to judicial control. Any wrong acts committed by them while carrying out their functions and outside of it could be heard or tried and also punished by the Diwani Adalats. Means earlier they were immune from the jurisdiction of the court, but now they were answerable before the judicial courts. The next provision was provision for the disputes between the government and the individuals. Suits against the government by private individuals could be brought forward and were tried by the Diwani courts. Indian natives had to sign a bond with the British subjects agreeing to go to court. British could recover claims from Indian natives and vice versa by signing a bond with each other agreeing to go to the court. The next provision or reform was establishment of Provincial Court of Appeal at the 4 divisions. Establishment of Provincial Courts of Appeal at the 4 divisions. Earlier, the appeal from Moffisil Diwani Adalats lay to Sadr Diwani Adalat situated at Calcutta. But this process for appeal was time consuming and very expensive. So, provincial courts of appeal were established at each division. That, that is at Patna, Calcutta, Murshidabad and Dhaka. Appeals from the Moffisil Adalat now lay to Provincial Court of Appeal, which were to be heard within 3 months of filing them. Means here time for appeal was also prescribed. These courts were presided by 3 covenant English servants of the company. Quorum was of 2 servants. It was an open court and could try revenue, civil and criminal cases. Means Provincial Court of Appeal could try revenue, civil as well as criminal cases. They could also try cases referred to them by the Sadr Diwani Adalats. Cases valued more than rupees 5,000 were referred to the king in council. The next provision was Indian law officers. Native officers given important post. Native officers were appointed by the Governor General in Council. Native officers were made munsif of the munsif's court at district level. This court could try cases up to rupees 50. Zamindars, tehsildars, etc. appointed as munsif in the munsif's court. Personal laws of Hindus and Muslims were applicable in cases relating to marriage, inheritance, caste, religious usages, and institutions. These personal laws were interpreted by the native officers, qazis, mufti, and pandits, who were appointed to assist the court to expound the personal law. Next provision, Sadr Diwani Adalat, as formally constituted, it was again constituted by Governor General and his council. It was the highest court of appeal in India. It was presided over by the Governor General and the council, who were the judges of the Sadr Diwani Adalat. Their function was to supervise the lower courts and to hear appeals from the provincial courts of appeal when the amount of the matter of the case was more than rupees 1000. Further, an appeal from the Sadr Diwani Adalat lay to the king in council if the amount of the matter of the case was exceed rupees 5000 or more than rupees 5000. Then the reforms in the criminal judicature. As per Judicial Plan of 1793, the Court of Circuit was merged with the Provincial Court of Appeal. The power of the collector as magistrate was taken away and was vested in the judges of the Diwani Adalats instead. As the collector had been deprived of his powers in revenue cases under Plan of 1793, likewise he was relieved of his magisterial powers in the field of criminal justice. The judges of the Diwani Adalat became the magistrate as per the Judicial Plan of 1793. Then the reforms in the legislative methods. Uniform pattern of regulations was introduced. Until now, any new regulation that was issued did not follow an uniform pattern. This was changed by making it a rule that any new regulation that would be made would have a title to explain the nature of the subject matter. So this was very important change which was brought by this system and contained a preamble which would state the purpose for enacting the regulation. Then the reforms in Muslim personal law. The Southern Nizamat Adalat was directed to follow the Muslim personal law to try and punish criminal cases, but with some modifications. The relatives of murder victims did not have a provision to pardon the murderer. The cruel and inhuman punishments, such as cutting off limbs of the offender, were replaced with punishment of imprisonment and hard labor for 14 years. The next provision was court fees abolished. Court fees, which was imposed in the Judicial Plan of 1787, was abolished. The court fee was abolished so that the people could easily reach to the court for securing justice. Next provision was, or next reform was legal profession. Sadr Diwani Adalat was to issue sanats or licenses to the pleader or lawyer who were to act as lawyers before various courts and who had applied for the same. The legal profession was recognized in India for the first time. The pleaders of the case had to have prior legal knowledge to be eligible to be a pleader of the court. The lawyers were to charge fee as prescribed by the government. Defects of the judicial plan of 1790. So let's discuss. The judicial administration of Cornwallis was very expensive. Another defect was the provisions of multiple levels of appeals made the judicial machinery complicated and slow moving. Thus, large number of cases remained pending in the courts for long time. The Indians were totally excluded or avoided from the judiciary except at very low level of Munsif's court or at low level of Munsif. Cornwallis was of a belief that the Indians were unworthy of holding any position of responsibility because of their character. Salaries provided to Indians were very low or no salary at all was paid to them for the discharge of judicial works. The non-payment of salaries to the munsifs led to the bribery and corruption. This distrust This distrust shown towards the Indians generated dissatisfaction among the native people as well as made the system less efficient as the English servants did not know and understand the custom, usages, etc. of the people. Therefore, Europeans could not understand nor provide solutions for the problem of the natives. Cornwallis did everything on procedural side, but he could not reform the substantive part of law, mainly the criminal law, which was based on Muslim law and had many defects. So let's conclude. The most remarkable point was that it was based on the principles of check and balances. The provision of fixed salaries to the judges and recognition of the legal profession were positive steps towards strengthening the judicial system and reviving the spirit of law and justice. This was positive point. Through his various judicial plans, Cornwallis was successful to uproot the evil of corruption. Though Cornwallis was a just administrator, he was seen as a racial discriminatory as he reserved all the high post of judicature for the Europeans. Even though Cornwallis almost perfected the administration of civil judicature, the problem of criminal law was still prevalent as the criminal law was based on Muslim personal law, which already had prevalent defect in it. So these are the references. With this, I have completed all the judicial reforms of Lord Cornwallis, that is Judicial Plan of 1787, Judicial Reforms of 1790, and Judicial Reforms of Lord Cornwallis 1793. Thank you.